From North Carolina, restaurants are being sued over their name. Texas-based chain Whataburger is taking the Tar Heel State restaurants to court, citing trademark infringement. North Carolina locations also called Whataburger, except the name is spelled with hyphens.
So the lawsuit claims the Texas-based chain reached out to the defendant several years ago when it decided to expand into North Carolina, and a confidential coexistence agreement was then signed between the two companies. But now the Texas chain accuses the North Carolina restaurants of forming a limited liability corporation behind its back. Well, let's get straight over to Chief Legal Analyst.
What's going on? I am your host, Dave, almost 10-year intellectual property attorney dealing with everything from patents to trade secrets to copyright, and you guessed it, trademarks. This is actually interesting. When I'm here in the Michigan area, and they unfortunately don't have a Whataburger here, a restaurant here in the Michigan, at least not of yet. We have a Wayback Burger, which I've been to, interesting burger, but we don't have a Whataburger. You guys have to let me know in the comments whether you have tried the Whataburger. And kind of let me know what's your thoughts of it. What's your take on it? Is it a good restaurant? Is it a good burger? How does it compare to, I guess, the Chick-fil-A's and the McDonald's, the Burger Kings of the world? Now, this is an interesting one, and I must say, I have to give a shout out to these local news stations, because typically you'll see these local news stations covering things such as criminal cases. They may even cover some civil lawsuits, civil cases that's going around, or that's out there, but they typically don't cover the IP, the intellectual property cases, lawsuits. So a shout out to this, Queen City News, specifically for covering this intellectual property lawsuits between Whataburger. Now you may be asking, hey, hold on, this doesn't make sense. So we'll get off into the video, and I'm gonna pull up the lawsuits, the trademarks of the Whataburger in Texas, and kind of explain to you how can this be, and hopefully you get some learning lessons out of this, because this is extremely important lawsuit, which hopefully you get some learning lessons. But you may be asking, number one, how are two Whataburgers, maybe different Whataburgers, coexisting, and how can they sue each other? That kind of maybe doesn't make sense. Is that a conflict of interest? So pretty much what you have here is you have a Whataburger that started in Texas, and it's a franchise similar to the McDonald's franchise, similar to a Burger King franchise, a Chick-fil-A franchise, and they have locations all over the country. So this Whataburger franchise started in Texas, started to branch out to different states outside of Texas, and they were looking to go into North Carolina. However, you have some owners that already own two Whataburger two Whataburger restaurants in the state of North Carolina. So the Whataburger franchise in Texas, who are looking to expand into North Carolina, actually called the Whataburger restaurants, the owners of the two restaurants in North Carolina, and said, hey, we're essentially looking to come in North Carolina, and we want to prevent you from using the word, or using the phrase, or the title, the name Whataburger for your restaurants in North Carolina. But it's this thing called common law rights. So, and I always tell people, backing up, and if the Whataburger franchise in Texas if they would have registered their term Whataburger for restaurant services, they wouldn't have even been in this situation. They would have called Whataburger up in North Carolina and say, look, we have a federally registered trademark for the term Whataburger for restaurants that you are infringing, and therefore you need to stop, or we're going to sue you. We're going to send you a cease and desist letter, and if you don't stop using the term Whataburger for your restaurant, we're going to sue you. That's what happens if you have a registered trademark. That's how easy it goes if you have a registered trademark. However, what happened was you had this Texas chain that did not, at least originally, file for a trademark protection for the term Whataburger for restaurants. And then you had this Whataburger franchise these restaurants in North Carolina that actually started a restaurant calling it Whataburger in North Carolina. And now they have common law rights, at least with respect to North Carolina. So then when the Texas franchise Whataburger calls them up and say, hey, stop using it, they're like, man, screw you. We already been using it before you came to Texas. Before you came to North Carolina, and before you actually registered the term Whataburger for restaurant services, and therefore we have common law rights. And now we can expand beyond the area that we've been using it, that is in North Carolina. However, we still have common law rights to use our term Whataburger for our restaurants in North Carolina. Hopefully you guys are picking up what I'm putting down here. So again, the Texas franchise that had the trademark Whataburger, they're looking to expand in North Carolina, but the North Carolina restaurant, they had common law rights because they were in existence before the Whataburger franchise in Texas trademarked the term Whataburger for restaurant services. I always tell people all the time, file a trademark application for your, file a trademark application for your business and all the classes that you need to go into early as possible. Because again, if the Whataburger franchise in Texas had filed the trademark for restaurant services, it wouldn't even been a issue at this point. They would have called the North Carolina chain and say, hey, you're using our federally registered trademark. Cease from using it, or we're going to sue you. It would have been as simple as that. However, now that the fact that the North Carolina owners of the restaurant Whataburger was using it before the Whataburger franchise in Texas have filed their trademark, they have common law rights and they can continue using the mark. Again, they can't. The North Carolina owners cannot expand outside of the geographical area that they're already using their Whataburger restaurant in. However, they can still use the Whataburger word mark in the area that they were currently using it before it was registered. So that's essentially what we have happening. Let's finish this video and then I'll pull up the Whataburger trademark and let you know how important trademarking your stuff is early as possible. So let's go back to the news coverage and go from there.
Khalif Rhodes.
Khalif, we kind of saw this coming with the legal aspects of this case. Where do you see this is going to go?
What a mess. How about that, right? I can tell you that this is problematic from the very beginning. First of all, you got to look at, these are two old companies, one 1957, the other 1967. And so
and that's important because the Texas chain was in existence in 1957 and the North Carolina chain came into existence, not the North Carolina chain, the North Carolina restaurants is, I guess I wouldn't call you having two restaurants a chain, but maybe some may disagree with me. But the North Carolina owners of the restaurant Whataburger, they came in existence in 1967. So the Texas chain started in 1957. The Whataburger owners in North Carolina, they came into existence in 1967, 10 years later. So again, if the Whataburger in Texas if they filed for a trademark in restaurants in 1957, it's not even a question. It's not even an issue. They're calling the Whataburger up in North Carolina and say, hey, stop using our mark or we're going to sue you. But the fact that they did not file a trademark for Whataburger for the restaurant services until after 1967, that gave the Whataburger in North Carolina common law rights to continue using it in that geographical area that they have already been using it before the other Whataburger location in Texas actually federally registered the trademark. Again, hopefully you guys are picking up what I'm putting down because that is a very important distinction. If the Whataburger in Texas would have filed for a trademark in restaurant services when they started in 1957, they would have had nationwide rights to that term, that word Whataburger, for restaurants all over the country, and they could have stopped the Whataburger in North Carolina from being in existence, at least under the name Whataburger. But the fact that they did not register the term Whataburger for restaurant services until after 1967, when the Whataburger in North Carolina was in existence, it gave Whataburger in North Carolina common law rights to the term. They could keep using the term. Again, they can't expand beyond their current reach, which was in North Carolina. However, they can continue using it in North Carolina in those locations that they had already been using it before it was federally registered. So again, it's important to federally trademark, register this stuff as soon as possible to give you nationwide rights. Hopefully that makes sense. Let's get back to the video and see what the gentleman is talking about here. But again, just to give you an idea, the Whataburger, the Texas franchise started in 1957. The North Carolina locations opened up in 1967 that included different owners. Let's go.
By a decade, but the one out of Texas is the
separated
older,
by a hyphen.
It's separated by a hyphen, and that was their attempt to try to distinguish themselves. But they do the exact same thing. They're a fast food chain that offers burgers and fries and different things like that. But they're limited. The one in North Carolina is 2 locations and 1 food truck. The problem was Texas wasn't in North Carolina. They had no footprint. But once they hit 1,000 locations, they started kind of getting closer to this area.
He said two things here that I want to point out. One thing he said, the North Carolina location tried to separate themselves by a hyphen. So it was still the same, the term Whataburger, but it seems like it was What-A-Burger, whereas the Texas chain was all one word without the hyphen. And we all know, if you've been watching my channel for any length of time, you know that the trademark, the standard, is likelihood of confusion. And I can tell you as an intellectual property attorney that putting hyphens between what and burger, it's still going to be a likelihood of confusion, or at least the courts is going to say that's a likelihood of confusion. Just because you have some hyphens, yeah, it's technically different, but that difference is still a likelihood of confusion between the consumers. If you driving up to a Whataburger and it has two hyphens, you're most likely going to think that it's still associated with the Whataburger in Texas that doesn't have a hyphen. So adding those hyphens are not going to overcome the likelihood of confusion, and therefore you're going to most likely still be liable for trademark infringement. That's the first thing that the gentleman talked about. The second thing that he talked about is the fact that, again, what I was saying before, the Whataburger in North Carolina, they had 2 brick and mortar restaurants and they had the food truck. So it seems like, again, they were able to continue to operate as they were currently operating because they had common law rights. And even though the Texas chain was looking to come up in North Carolina, they can't, because the North Carolina chain was already operating common law rights. The Texas chain cannot just say, hey, you guys can't use the term Whataburger anymore. However, they can stop them from expanding their current reach, because now the Whataburger in Texas has that federal registered trademark for restaurant services. Let's get back to it and see what the gentleman has to say.
Atlanta, and now they're like, okay, we got one in Greenville, South Carolina. North Carolina, it's time. 2022 comes around and they're pushing their big thing of we're bringing it to North Carolina. They reached out to the Whataburger here and said, look, we're going to be here. We'll still allow you to use your name, but you can't do anything else with it. What they didn't know is that,
look, he's talking about they still allow, and that's how you gotta understand I guess what is going on, the negotiation that's going on between the Texas chain and the North Carolina chain. He's saying that the Texas chain, as they're coming into North Carolina, they're saying, hey, we'll still allow you to use it. If I'm the attorney in the North Carolina chain, I'm saying you don't have a choice but to allow us, because we have common law rights. Now, again, we can't expand it. And that was part of the agreement that, hey, you can use it as you currently been using it, which the court was going to allow you to do that anyway. The Texas chain of Whataburger, you're not doing us a favor by saying we can continue to use it because we have common law rights. But again, part of that negotiation or that contract is saying, hey, we can expand. And the Whataburger, the Texas chain, they have a legitimate point in terms of not being able or preventing the North Carolina chain from expanding their use of the 2 brick and mortar locations in a food truck based on the Texas chain having a federally registered trademark that gives them nationwide protection. So let's go. But I thought that was interesting because the Texas chain made it seem like they're doing them a favor. It's like, no, we're going to be able to use it anyway because we have common law rights for these areas. Let's go.
that this location went out there, what they alleged in their complaint is went out there, formed an LLC, and decided to use their food truck in different capacities. They looked at it as a breach of contract, and they said, you know what, now because you've breached this contract, you can't use the name in any capacity, and we're going to sue you for a number of things, specifically unfair and deceptive trade practices, unfair enrichment, unjust enrichment. I mean, a number of claims that all equal money.
You know what? I mean, just listen.
So that's a good point. So pretty much what he's saying is, look, you have common law rights. The Texas chain is saying, hey, you have common law rights. We get that. So we really, even though they're telling them, the North Carolina chain, that we're going to allow you, they really had no choice but to allow them because they have common law rights to use Whataburger in North Carolina in the 2 brick and mortar locations as well as the food truck location that they currently be using it. But what happened was now the Whataburger in North Carolina, they're trying to take their food truck on the road. Maybe they were in Raleigh, North Carolina, and they're trying to take their food truck to Charlotte, North Carolina. Nope. You didn't have common law rights to use the term Whataburger in Charlotte, North Carolina. So number one, that's trademark infringement. But then number two, that's a breach of our contract that we have that's saying, hey, you're going to stay within the area that you already have been using the term in. So again, by the North Carolina, by that restaurant trying to take their food truck on the road, their show on the road, then that's when the Texas chain like, no, we're not going to allow that. You weren't in Charlotte, North Carolina. You weren't in Durham, North Carolina. You were only in Raleigh, North Carolina. Maybe I'm pronouncing that wrong. You were only in Raleigh. So we're going to, again, we have to allow you to continue to use your food truck in Raleigh, but you weren't in Charlotte. You weren't in Durham. Heck, you weren't in Fayetteville, North Carolina. So you can't take your show on the road to those cities. It seems like that's maybe what was going on between the North Carolina-based restaurants of Whataburger. They were trying to take the food truck portion of it on the road, and the Texas food truck, they caught them at that point and said, you can't do that. That's a breach of agreement. That's trademark infringement. And that's where they drew the line. So let me, hopefully you guys picked up what I'm putting down. I want to go to one more thing to kind of show you how important it is to register these trademarks. So again, as we talked about earlier, and the gentleman talked about, Whataburger in North Carolina, in Texas, was around 10 years before the Whataburger popped up in North Carolina. So as you look at the Whataburger, and I'm assuming that the Trace Eguales Enterprises and Whatabrands LLC, both Texas company, I'm assuming that those are part of the same company. Even though they're two different owners, I'm assuming that it's essentially owned by the same company. So you can see here they have two Whataburger trademarks. One in hamburger sandwiches is the class, which is class 30. The other is restaurant services and drive-in restaurant services, which is class 42. This is a very important distinction. I'm gonna bring it back on myself. When you are trademarking your names or your logos, you have to pick what class you're going to trademark it in. It's not like you're going to file a trademark application with the United States Patent and Trademark Office, and that's going to give you trademark protection, everything under the sun and everything under the sun. That's not how that works. You have to pick what class or what kind of business avenue that you're operating in. You have to get trademark protection in each of those kind of business streams. So in this case, we call them classes at the USPTO, and the classes is hamburger sandwiches, which is class 30, and then restaurant services, which is class 42. Those are at least two of the classes that the Whataburger in Texas ultimately got registered protection in. But let me show you what happened here. So if we click on here, the Whataburger, it's not going to do it. So it's not going to do what I wanted it to do. So what I'll just say here. So the Whataburger for hamburger sandwiches, that was the first trademark, and that was actually trademarked by the Texas chain when it opened in 1957 it was. And the Whataburger for the restaurant services wasn't trademarked until 1968. So again, hopefully you guys are picking up what I'm putting down. If they would have filed the Whataburger trademark on the left here, that application for hamburger sandwiches, if they would have added restaurant services also, which is class 42, in that 1954 application, when they initially opened up the franchise Whataburger, the location Whataburger in Texas, they would have been able to prevent the North Carolina chain from ever existing under the term Whataburger. But the fact that they only filed the trademark application for the hamburger sandwiches and not the restaurant services, and the North Carolina is using Whataburger for the restaurant services, or for essentially the name of the restaurant. Now the North Carolina company cannot use the term Whataburger. They can't call a sandwich Whataburger, but they can call their restaurant Whataburger because, again, as you see here on the left, the Texas company only registered it for hamburger sandwiches in 1954 and didn't register the restaurant services until 1968, which was after the formation of the Whataburger in North Carolina. So hopefully you guys understand that distinction, and hopefully you guys, again, as I say before, you definitely want to file trademark applications, especially for the big ways that you're going to use your trademark name. So if it's for hamburgers, trademark it for the hamburger class, which is the sandwich class, which is class 30. If you're using it at the beginning for a restaurant, you may want to add that class 42 to that application. It's going to cost you a little bit more, but it's going to avoid a situation where somebody else can open up a restaurant and use that same term, and because you haven't filed for protection for that particular class. If they would have added class 42 to that 1954 application, they would have been good to go. But the fact that they didn't add class 42 until 1968 for the restaurant services, which is when that North Carolina company was already in existence, that gave that North Carolina restaurant common law rights to the term Whataburger. Hopefully you guys are picking up what I'm putting down and this makes sense. It's extremely important as I bring it back on myself too, especially for the main ways as you're starting a business, whether it's a restaurant, a clothing company, whatever the case may be. Make sure you file trademark applications as soon as possible, and you will want to include all the different ways you're using that trademark application at that point of time in that trademark application. Again, it's going to cost you a couple dollars extra because you're filing multiple classes, but if somebody else tried to come along afterwards and use your name, your logo in one of those classes, you can essentially send them a cease and desist letter in a lawsuit if they don't comply with the cease and desist letter and prevent them from using that term. Again, I'm telling you, if the Whataburger in Texas would have filed the Whataburger for hamburger sandwiches and restaurant services in 1954 when they filed that original application, they would have been able to prevent the Whataburger in North Carolina from ever using that term for restaurant services. But because the Whataburger didn't file it for restaurant, and I would imagine that, I bet you that the Whataburger in Texas, they filed it in 1968 when they first heard about the Whataburger in North Carolina. It's too much of a coincidence. In 1967, the Whataburger is formed in North Carolina by different owners, and then in 1968, the Texas-based chain filed for a registered trademark application for the term Whataburger in restaurant services. They knew they were calling most likely they were calling their restaurant Whataburger back in 1954. So they should have trademarked the term Whataburger, not only for the hamburger sandwich as they did, but they also should have trademarked it for restaurant services, and they would have been good to go. Hopefully you guys got something out of this video. Again, I'm trying to provide you guys value, and this was something that hit the national news here recently, and I thought this was a good learning lesson. Make sure you file your trademark applications when your business starts, and then file them for every I guess business avenue or way you're conducting businesses, whether in this case it's a restaurant, whether it's a hamburger sandwich. Heck, if you're selling clothes with the term Whataburger on it, you want to file it in Class 25 for clothing and apparel. Make sure you're protecting each avenue that you're conducting business for your trademark as soon as possible. Let me know in the comments if you guys what you guys think about this one. Do you think the Whataburger in North Carolina is wrong for what they're doing in terms of trying to expand within a state with their food truck? Or do you think the Whataburger, the Texas franchise is being petty and they should allow them to continue to go in North Carolina? I may break down every Sunday. I do a live stream on an intellectual property lawsuit. We go through the lawsuit, pull up the social medias, see what else we can find and talk about it. I may do this one on Sunday, or at least one of these Sundays, to kind of go through the lawsuits of the Whataburger franchise in Texas. But again, let me know what you guys think of this debate or this dispute between the two restaurants, Whataburger, the Texas chain, and the North Carolina chain. And again, I'll see you guys next time. Peace.